Hi guys, so this video lesson is going to cover the Red Hill outing case. It's going to cover Hermitage Methodist Homes, the letting case, and then at the end I'm going to go through and talk you through the answers to problems 2G and 2H. Again, when we meet on Wednesday of this week, we're going to start with the Albee case, so pages 235 through 258. I really apologize if this video is boring. I did my best. I'm still a little under the weather, but I gave it my best shot. Hopefully this is helpful. I'll leave it up so you can review it again and again. And feel free to come to class on Wednesday with questions. All right, here we go. All right, so just to recap the facts in the Red Hill Outing Club v. Hammond case. So in 1956, David Hammond bought land in Maltonborough, New Hampshire, and this land was known as Red Hill. He subsequently cleared it for use as a ski slope and formed the Red Hill Outing Club to operate the ski slope. From 1969 to 1979, the club operated Red Hill as Hammond's tenant, providing a rope tow and free lessons to club members and all of the residents of the city. In 1979, for nominal consideration, Hammond quitclaimed Red Hill to the club in fee simple, subject to a condition subsequent, providing for re-entry if the club failed to provide, quote, skiing facilities to Maltonborough residents for a period of 2 consecutive years, with an exception for acts of God such as inadequate snowfall. All right, so for various reasons, business at Red Hill declined after 1988. The club did not obtain a rope tow permit for 1992 through 1993 or 1993 through 1994 and closed Red Hill to skiing entirely in 1993 to 1994. In October of 1994, Hammond notified the club of his election to terminate the club's estate. And so the club brought this suit seeking a declaratory judgment as to their parties' rights. After a bench trial and a view, the trial judge denied Hammond's claimed forfeiture, holding that the deed language requiring skiing facilities should be strictly construed to require only that the club maintain and make available the premises as a ski slope. The judge said that the club had substantially complied by remaining in existence and offering the hill as a ski slope, even without the tow rope facility. The club's discontinuance of skiing in 1993 to 1994 was not of sufficient duration to constitute a breach. So on appeal to the New Hampshire Supreme Court, the New Hampshire Supreme Court here affirms that holding, and they held that the rule of strict construction rather than a search for the party's intent applies to fee simple on a condition subsequent. Okay, so the first question that I think we answered in class, but you want to make sure that you understand, is why this language uh, is a fee simple subject to a condition subsequent, okay? And the reason is you have the conditional language in combination with right of re-entry language. So that's why we have here a fee simple subject to a condition subsequent. Okay, so what is Hammond's argument here? So remember that Hammond's argument here is, look, what I really meant to say is that I wanted Red Hill to operate this facility as a ski facility. I wanted lessons, I wanted a ski tow. I did not want it just available as a ski slope. And his argument is that the court, instead of strictly construing the language, should look at the intent, should look at the intent behind the language. But as I mentioned earlier, we know that the court here, the New Hampshire Supreme Court, rejects Hammond's argument. And the court says here that it's going to strictly construe this language, this fee simple subject to a condition subsequent language, because of its capacity to cause forfeiture. And so the court here is refusing to give the grantor no more than the exact legal right that was written in the document. And it goes so far as to also say that any ambiguity in the document is going to be resolved against forfeiture. Now, the question then is why? Why is the court so adamant about following a strict construction of the language here? And the reason is that forfeiture of property is a drastic consequence, and generally speaking, uh, it is disproportionate to the breach. So here, the court is not willing to forfeit the property if all that Red Hill did not do is provide a a tow rope, excuse me, and also provide um, lessons and all of the amenities that would go with a ski slope here. Finally, the court here does give an answer to the question, um, you know, what does it take to breach fee simple subject to a condition subsequent? And its answer is that it must be such neglect as to indicate an intention to disregard the condition, right? And so anything that would meet the test of substantial compliance is going to avoid breach. So it's got to be neglect and disregard for the condition for breach to take place, at least in the New Hampshire court's view. Now, one question you want to ask yourself is, did Hammond, in bringing his cause of action, when he did, jump the gun? In other words, did he sue too soon? Um, and it's probably the case that he should have waited it out another ski season before electing to terminate. So the deed allowed forfeiture if the club failed to provide skiing facilities for a period of 2 consecutive years. As of October 1994, the club had discontinued ski lessons for more than 2 years and had failed to provide the rope tow for 2 years. But it had discontinued skiing for only one season, the 93 to 94 season. So, as of October 1994, Hammond's case for forfeiture consists of convincing the court that the skiing facilities includes more than just making the slope available, or that 2 consecutive years is satisfied by discontinuance of skiing for one full season if the season extends over parts of 2 years, November through December in 93 and January through March of 94. So, had the club discontinued skiing in the next season also, the 94-95 season, Hammond would have had a much stronger case. Okay, so now let's look at defeasible fees with executory interest. So there's a short block of text on page 223 in your text that you should read and make sure you understand, that talks about defeasible fees with an executory interest. And basically, what this means is that upon the violation of restriction, title in the property will now pass to a third party. So before, when we're dealing with, when we were talking about fee simple subject to a condition subsequent and a fee simple determinable upon the violation of the restriction, the title passed back to the grantor. So with executory interest, the title will now pass to a third party. You also want to make note and make sure you understand the naming conventions given on page 223. Okay? So if the restriction uses conditional language, then we call the executory limitation fee simple subject to an executory limitation. Okay? And the example there for you of a fee simple subject to an executory limitation is example B on page 223. Okay? If the restriction uses language of duration, we say it's a fee simple determinable with an executory interest. Okay? And the example of that language given there for you on page 223 is example A. All right, and so with that, we can return to our chart. So now we have talked about all of the three types of defeasible fees that we will talk about in this unit. The fee simple determinable, the fee simple subject to a condition subsequent, and we just talked about the fee simple subject to an executory limitation. Okay, now how do you tell these apart? Okay, let me give you some tips. So, how do you distinguish between the three types of defeasible fees? The first question that you have to ask is who holds the future interest? Is it a grantor or a third party? You can look at the third column of the chart there and see that if it's a third party, it's going to be an executory interest. It's going to be a fee simple subject to an executory limitation. So it's either going to be a fee simple subject to an executory limitation or a fee simple determinable with an executory interest. Now, if the future interest is not in a third party, if it's in the grantor, then we know it's either going to be, depending on the language that's used, the creation language that's used, we know that it's either going to be a fee simple determinable or a fee simple subject to a condition subsequent. Okay, let's take a look at the Hermitage Holmes case. So, the facts for this case, you have a gentleman by the name of Jack Adams, and he executed a will in 1956. He executed a codicil to that will in 1968. And the codicil placed the residue of Jack Adams' estate in trust for the benefit of Prince Edward School Foundation, so long as it admitted only members of the white race. If the school ceased to operate for a year or admitted non-whites, then the interest in the trust passed to the Miller School. Then it passed to Seven Hills School, then to Hampton Sydney College, and then finally to Hermitage Methodist Homes of Virginia without any of the limitations with respect to admissions practices. Okay, so here's one way that you could visualize the transactions that are happening, right? So you have the grantor, Jack Adams, and again, we know that he's leaving interest to Prince Edward, but he's leaving it subject to the restriction that I discussed earlier. So the first question that you want to ask yourself is you want to characterize uh, the restriction. You want to characterize the interest that Prince Edward has received. Okay? And you look at the language there for you on page 224, and the clue is in the first few words of the restriction or of the clause, right? So it says, so long as Prince Edward School Foundation, and then goes on to talk about what the restriction is. So the key here is the durational language so long as, right? So you have this language so long as, and so that lets us know that what Prince Edward is receiving from Jack Adams is a fee simple determinable with an executory interest. All right, so fee simple determinable because of the durational language with an executory interest because if the restriction is not satisfied, then the interest vests in a third party, right? So instead of the interest going back to Jack Adams, the interest is going to go to the Miller School. And if the Miller School violates that restriction, then the interest is going to go to Seven Hills. And if Seven Hills violates that restriction, then the interest will go to Hampton-Sydney College. And then finally, if Hampton-Sydney College violates that restriction, the interest vests in Hermitage Homes. And so if you were going to we characterize uh, the interest that Prince Edward has. If you're going to characterize the interest that the other parties have, then you would say that they all have an executory interest, right? They all have an executory interest in the property because they are third parties that the property could potentially vest in if the restriction is violated. The other thing that you should note here is that uh, the executory interest uh, in fee simple absolute was given to Hermitage Methodist Homes, right? So Hermitage Methodist Homes is not subject to the restrictions that the other educational institutions are subject to. Okay, so remember, Miller School subject to restriction, Seven Hills subject to restriction, Hampton City College subject to a restriction. Hermitage Homes not subject to any restriction. Okay, so the facts tell us that the restriction was violated at some point. Each one of the schools or school systems admitted non-white students, but there's also this concern um, about whether or not the restriction, which is racially discriminatory, is unconstitutional and therefore invalid. And so at the top of page 226, the Virginia Supreme Court here, uh, they assume, without really addressing the racially discriminatory and unconstitutional issue, they assume that these provisions are unconstitutional and void, just for the sake of argument, but they don't really make a ruling directly upon that, and that's something that's sort of beyond the scope of this course, having to do more with constitutional law. But for the purposes of this case, the court here says, okay, we're going to assume that the restrictions are void. So then the question then becomes well, if the restrictions imposed upon uh, Prince Edward, imposed upon the other parties that have an executory interest, if those restrictions are void, then how does the court then interpret the language of the provisions? The Supreme Court here, the Virginia Supreme Court, walks through that rationale on page 226. Okay, and you see the argument that Prince Edward makes. Prince Edward makes the case that well, what you should do is you should strike the condition. You should strike the condition that's void, and leave intact the fee simple. And if you accept Prince Edward's argument, and they use the Meek case to make their argument by analogy, if you accept the Prince Edward argument, then Prince Edward would obtain the interest in fee simple absolute, right? Uh, so why does the court not accept Prince Edward's argument? Why does the court uh, distinguish the Meek case? Well, what the court says is that in the Meek case involved fee simple subject to condition subsequent language. And when you're dealing with fee simple subject to a condition subsequent, the offending language can be stricken from the provision without changing the essential nature of the estate. However, in this case, remember, going back to the provision language that I pointed out on page 224, in this case, we don't have a fee simple subject to a condition subsequent. We have a fee simple determinable because we have the durational language, we have the so long as language. Okay? And what the court says is that with fee simple determinable language, the offending language cannot be stricken. Okay? Instead, the entire gift is struck. So there in the reprinted opinion for you on page 227 of your text, in the second full paragraph, the court says, therefore, unlike in Meek, the interests of the educational charities fail completely. We strike the entire gift to Prince Edward and the gifts to the other educational beneficiaries because the offending language cannot be stricken from the provision without changing the essential nature and quality of the estate. Accordingly, what happens is that the only executory interest to survive, because it is not subject to any restriction, is Hermitage Homes. The last thing that's interesting that the court points out is the court points out that let's say that these racially discriminatory limitations were in fact constitutional. The court says that this result would occur if those provisions were constitutional because all of those organizations had admitted non-white students. So either way, the interest in the trust income should be paid to Hermitage Homes. Okay, so let's take a look at an example applying what we learned in the Hermitage Homes case. So the question that this example asks is, in view of what we learned in Hermitage Homes, how would a court modify the two conveyances that are in the bullet points below, right? And understand that in this state, restraints on the first marriage of another are invalid. So both of those conveyances are invalid because they violate the state law. And so the question is, how would a court modify each of the conveyances below? All right, so take a moment. It would help if you just write out each one and then think about how the court would modify each of those conveyances. And the next slide that I'll show you is the answer to that. But pause the video here and try and come up with the answer on your own. And then the next slide I'll show you are the answers. Okay, here are the answers to the question. So if you look at how it was modified, right? So you look at the first conveyance, which was fee simple determinable. You see that the entire gift to A is struck. So all that's left is O transfers Blackacre to B, right? And you can see how this parallels the result in Hermitage Homes. Now compare that to what would happen if the gift was worded as a fee simple subject to a condition subsequent. That is the second bullet point. Modifying that, the gift would end up being O transfers Blackacre to A. So you see how choosing between fee simple determinable language or fee simple subject to a condition subsequent language can affect the transfer of the gift if some of the restraints that are used are found invalid or unconstitutional. Okay, guys, now let's look at the Ludington and Northern Railway v. Epworth Assembly case. Okay, so here's what's going on in this case. So Epworth Assembly is a corporation consisting of owners of resort cottages that are situated along Lake Michigan, and they wanted a railroad service to provide to their members with access to the cottages that were on Lake Michigan. So in 1916, the Assembly deeded 4 strips of land to Ludington and Northern Railway. 3 of the deeds stated that the conveyances were for railroad purposes only. And the 4th conveyance provided that if the parcel conveyed was not used for railroad purposes for 1 year or longer, all of the land described should revert to Epworth Assembly. So, as the case details the running of the trains along the tracks, it became a source of friction and controversy between Epworth Assembly and the railroad, basically because of the derailments that blocked traffic and uh, pose a danger to the people living there because of the heavy equipment needed to correct any derailment that had occurred. So then in 1981, the railroad ceased running trains on the track, but they continued to derive income from investments and renting out its railroad cars. And then in 1988, the railroad sued for an injunction to prevent Epworth from constructing barricades along the tracks. And they also sued or sought a declaratory judgment action um, to determine the party's interest in the strips of land that were conveyed in the original 1916 deeds. All right, so what you need to understand about this case is that it's dealing with a statute. And in the state of Michigan, Michigan has a statute that limits the duration of the possibility of reverter and rights of reentry. And the statute cuts off reverters and power of termination that were created prior to the statute. So this would be an example that would apply um, if the specified contingency does not occur within 30 years of the creation of the defeasible fee or within 1 year of the effective date of the statute. So let's visualize this. So essentially what the statute is saying is that the right of termination is unenforceable if it does not occur within 30 years after the interest was created, right? So you have a 30-year period if the condition doesn't occur to cause the right of termination or possibility of reverter, then it is terminated, right? So it can't be used. Now the statute does say it provides that look to keep the power of termination possibility of reverter alive, you have to file written notice. You need written notice is required to preserve the right of termination. If that is not done, then the power of termination possibility reverter is in fact terminated, right? And all of that discussion is there for you on pages 233 and 234 of your text. So in this case, obviously, if we look at the time, our the interest was created in 1961. 19 excuse me. The interest was created in 1916, and it's not until 1981 that the railroad stops using the land for railroad purposes, and so that is far beyond the 30-year time period. And so here the court appeals the trial court decision that basically found that uh, Ludington, the railroad company, held the property in fee simple because Epworth's possibility of reverter had been extinguished because it did not record a written notice that it desired to preserve its interests. The court also went on to say that the statute was constitutional because it was a reasonable adjustment of the rights and responsibilities, and it served a legitimate public purpose. And that purpose was to reduce impairments to marketability of title caused by these lingering possibility of reverter and right of reentry clauses. All right, guys, so now let's look at problem 2G. Problem 2G is on page 216, and there are several examples given for you there of ambiguous drafting, and the what you're trying to figure out when you look at these questions is what restriction is created based on the language, right? So one thing that you need to know about that we haven't talked about yet is covenants. And note 6 on page 215 uh, gives you a brief explanation of what a covenant is. And a covenant is simply a promise by the grantee to use or not use the land in a certain way. And if the covenant is breached, a covenant does not result in forfeiture. Instead, remedies for breach of a covenant include damages or an injunction. So that's important to know when you see a promise by the grantee to do or not do something. That typically is going to be interpreted by the court as a covenant and not necessarily as a restriction like a fee simple determinable or a fee simple subject to a condition subsequent. So then if you look at 2GA, 2GA, the wording there, it doesn't create a fee simple determinable. It doesn't create a fee simple subject to a condition subsequent. In fact, all it states is language of purpose only, and therefore there are no real legal consequences for not following the language in that's listed there for you in 2GA. So it's just a wish or request. It's not language that would result in forfeiture. 2GB is an example of language that would create a covenant instead of a defeasible fee. So that would be language of a covenant. Again, breach of a covenant results in remedies of damages or an injunction, but not forfeiture of property. The answer for C is given, so I will skip C. Okay, and then 2GD and 2GE are based on real cases. You can read there in the parentheticals how the courts dealt with the uh, the ambiguity in the language in both of those conveyances. So read through that. The answers are there for you, or at least how the court resolved that. If you have any questions about 2GD or 2GE, I am more than happy to answer them in class or office hours. All right, so problem 2H is a follow-up to the Red Hill case, and the purpose of problem 2H is to illustrate for you what does it take for a breach of these types of restrictions to occur? What does it take for forfeiture to occur? So the answer to 2HA is that the grantor is not going to recover the property. And so why? Well, first, non-use is not the same thing as abandonment. Okay. In addition, where the transferor specifies a restriction, and here the restriction is to public park uses, and they don't specify a time for compliance, the grantee has a reasonable time to perform, and in this particular case, the court held that 6 years was not an unreasonable period of time. All right, take a look at 2HB. So in 2HB, again, the answer here is that the grantor will not be entitled to recover possession. And make sure that you understand why. And under this particular set of facts here, all it says is that the grantor ceased to use the premises for church purposes for 18 months due to lack of funds. So the grantor didn't go out, I'm sorry, the grantee did not go out and use the premises for something other than church purposes. It just didn't use it. So the court interpreted that as not an activity that would result in a breach. Now, what about 2HC? Now, surely here, this is the type of activity that would result in a forfeiture, right? Well, wrong. So again, in C, the grantor is not going to be entitled to recover possession. And the issue here is the grantor is using the premises for church purposes, but also uh, using it for non-complying reasons as well. And the idea here is, again, remember that courts disfavor forfeiture, and so these uses that are illustrated in 2HC are seen as minor or temporary breaches. And generally speaking, most courts are going to excuse minor or temporary breaches, such as the set of facts given in 2HC. Okay, so now let's take a look at 2HD. So after reading the facts there, again, the question is, does the grantor or is the grantor entitled to recover possession? And again, the answer here is no. And so this problem is to illustrate that when courts sometimes are going to look at long-term compliance as a show of good faith, and they're going to look at changing conditions, and if the grantee has complied for a long time, and changing conditions dictate that the grantee uh, can violate the restriction or uses the property for a purpose outside of the restriction, then some courts will liberate the property from the restriction and terminate the restriction. And if you read some of the information in the parentheticals in 2HD, you'll see just that, right? All right. So last question that we'll do is 2HE. All right. And then finally in 2HE, um, we have a case where, assuming that the use of the park is discontinued, then the grantor here will in fact recover the property. Okay, if you have made it this far, I have a special treat for you. So, if you are ever in New Orleans in the near future and you're looking for a great sandwich, I would highly recommend you go to Turkey and the Wolf. This is a picture that I took of the restaurant. It's on 739 Jackson Avenue. And the sandwich that I had when I went to Turkey and the Wolf was a sandwich that I had not had since I was a little kid, which was a fried bologna and cheese sandwich. And when I tell you that it's worth the cab ride, it's worth the long line that you have to stand in, um, I mean it. This is one of the best sandwiches I've had in my lifetime. Highly recommend it. Thank you for your attention. Thank you for listening. And I'll see you guys on Wednesday.